Okay, so we've got this pretty interesting case you sent over.
Yeah.
On the surface, it looks like just your typical, builder and homeowner kind of falling out over a bill, right?
Yeah.
Homeowner hires a contractor, things get a little messy, dispute over the final payment.
Hmm.
But the thing that's so interesting about this one is the initial judgment went against the homeowner,
Right.
Lorraine Lee,
Mhm.
for over £79,000,
Wow.
all based on an adjudicator's decision.
Yeah.
But, and this is where it gets really interesting, that's really just kind of the tip of the iceberg.
Yeah, the story takes a pretty sharp turn from there.
So this deep dive is not going to be some, boring legal lecture or something like that.
No.
We're going to get right into the weeds here of, construction contracts and this process called adjudication and what can happen when things go wrong.
Yeah, and particularly how what seems like a really simple disagreement can escalate into a very complex legal battle with significant financial consequences.
Yeah, and we're going to try and make this so it's clear for you listening at home.
Right.
Whether you're a homeowner yourself and maybe thinking about renovations, or you're a contractor, or you're just interested in how these things work.
Mm-hmm.
We're going to break it down so that you can understand it without getting bogged down in all the legal jargon.
Yeah.
All right.
Absolutely.
So our main source material today is the High Court judgment in Levy Chartered Properties.
Mm-hmm.
And this judgment lays out the entire dispute. It gives the judge's reasoning behind the decision.
Yeah.
And what we want to do is we want to pull out the really critical parts of this case, focus on why Mrs. Lee ended up challenging the adjudicator's decision.
Right.
And more importantly, what you listening at home can learn from this so you can hopefully avoid a similar situation, right?
Yeah. Yeah. And I think one of the things that's most interesting about this case is it really highlights that tension between, the intended speed and efficiency of adjudication.
Right.
And then the absolute need to follow the proper legal procedures.
Yeah.
Adjudication is designed to provide very quick resolution.
Yeah.
But as we'll see, even seemingly minor missteps can have some pretty major consequences.
Absolutely. So to set the scene for you, back in January of 2008, Lorraine Lee hired a company called Chartered Properties to carry out some renovations on her London home, specifically a basement and ground floor refurbishment.
Right.
They used a standard form of contract.
Yeah.
The JCT Minor Works building contract from 2005.
Okay.
And the project architect was David Mercer from DVM Architects.
Got it.
The original contract value was just under £240,000 with a planned duration of about 7 months.
So a fairly sizable project.
Yeah, and as you would expect, this contract would have included clauses relating to things like practical completion, when the main construction works are substantially finished,
right,
and the release of retention.
Yeah, retention is a percentage of the contract sum that's usually held back as security against any potential defects.
Yeah.
So it's usually released in stages after completion of the project.
So practical completion was certified in September 2008.
Okay.
And subsequently, the architect issued a certificate for a partial release of retention, which was a little over £6,000.
Okay.
However, Mrs. Lee wasn't completely satisfied with the work.
Right.
And she actually issued a notice of proposed deductions.
Okay.
And she withheld payment of that certified sum.
Got it.
Then in January 2009, Chartered submitted their final account, claiming around £79,000 plus VAT.
Okay.
After taking into account previous payments.
Mm-hmm. And this is very common. This is a very common point at which disputes arise in construction projects.
Yeah.
The final account can often include costs for changes to the work, variations, claims for delays, things like that.
Yeah.
That maybe the homeowner wasn't expecting.
Yeah.
Or didn't explicitly agree to.
So according to Ms. Lee's statement, she reviewed this final account with the architect in early February 2009. She identified what she believed to be numerous errors in the account, duplicate charges, some inflated costs.
Right.
And as a result, she basically relied on the architect to discuss those discrepancies with Chartered.
Okay.
And try and get them resolved.
Yeah, so this really highlights the role of the architect as the contract administrator.
Right.
They often act as that crucial intermediary between the homeowner and the contractor.
Yeah.
And they're tasked with assessing claims and certifying payments.
Yeah.
But, their effectiveness in resolving disputes can vary a lot, depending on, the specifics of the situation.
Right.
And the communication dynamics between the parties.
Absolutely. Now, this is where things start to get really interesting.
Okay.
It appears that those discussions between the architect and Chartered actually reached a point where Chartered indicated that they were willing to drop their entire claim.
Oh, wow.
If Mrs. Lee would do the same, reciprocate and drop any counterclaims that she might have.
Interesting.
And the architect communicated this to Mrs. Lee in early May of 2009.
Okay.
And on May 7th, she actually emailed the architect, and she copied Chartered on the email saying that she was in agreement on the condition that Chartered confirmed in writing that they wouldn't pursue any further payments.
So it sounds like they were on the verge of reaching
It sounds like it.
a settlement.
Yeah. And then the very next day, May 8th, Chartered's representative, a Mr. Reeves, replied to the email.
Okay.
He said he was happy with this, but he introduced a specific condition. He said that both letters, formally confirming the withdrawal of claims, had to be sent to the architect's office.
Right.
And the architect had to witness the exchange.
Interesting.
And actually confirm the agreement by both parties.
So it seems like they wanted to formalize it.
They wanted it done properly,
in
a documented way. But here's the unbelievable part.
Okay.
According to the judgment, there was very little to no communication after this for the next 2 to 3 months.
Oh, wow.
And those crucial letters were never actually written.
Oh, so they had this agreement in principle?
Yeah.
But it never really materialized.
No, never actually exchanged.
Wow, so you can really sense that breakdown in trust happening there, right?
Yeah.
Like, they both seemingly agreed, but the lack of follow-through just created that breeding ground for future conflict.
It really did. So fast forward a little bit, and despite the settlement remaining unfinalized, Chartered decides to refer the dispute to adjudication.
Okay.
And they asserted that the dispute arose from the architect's alleged failures regarding instructions, certifications, extensions of time, and the valuation of the final account, and also from Mrs. Lee's alleged failures concerning site possession and making payments.
Right.
So they listed out all these reasons why there was this dispute.
Yeah, and just to clarify for our listeners, adjudication is a specific form of dispute resolution.
Yeah.
In the construction industry.
Yeah.
It's designed to be a swift and temporarily binding process.
Right.
If the construction contract has an adjudication clause, which this one likely did, either party can refer a dispute to an independent adjudicator for a decision.
Exactly. And Mrs. Lee's immediate response, this was in an email sent the same day, was to point directly back to Chartered's email from May 8th, where they had discussed both parties dropping their claims. And Mr. Reeves from Chartered then claimed as he had been trying to get the architect to facilitate this exchange of these formal letters, but he felt he was being ignored.
Okay.
And Mrs. Lee countered, saying that she believed that they already had a confirmed agreement in writing, via email.
Right.
And that those formal letters were just a formality.
Okay.
And she even questioned why Mr. Reeves hadn't contacted her directly.
Right.
If he felt the architect wasn't responding.
Yeah, you can really see the trust just eroding at this point between the parties. And
then it gets even more complicated.
Okay.
So Mr. Reeves replies again. Late August 2009. And he reiterates that he had asked the architect to prepare a letter for both parties to sign. Okay. But that he had been ignored. And then he kind of changes things up. Okay. He says he would consider a settlement if Mrs. Lee paid his costs. Wow. Of £20,000.
So they were willing to drop everything. Yep. And now they're asking for
20 grand.
20,000.
Yeah.
That's a pretty big shift.
It is, yeah. So then to add to all of this, the architect, Mr. Mercer, emails Mrs. Lee.
Okay.
And this is in early September. And he expresses his surprise and disappointment that Chartered had initiated adjudication.
Wow.
Because he firmly believed that both parties had agreed to a settlement with no financial implications.
Yeah.
And he actually said that he hadn't received any communication from Chartered suggesting they were dissatisfied with this, agreement via email.
Right.
And that he had assumed that the formal letter exchange wasn't a priority for either side.
So the architect's account here is pretty interesting, because it really does support Mrs. Lee's understanding of the situation.
It does.
It really begs the question why Chartered would decide to pursue adjudication at this point.
Yeah.
Despite that apparent agreement.
Right.
And the architect's belief that they had a deal.
Right. So unbelievably, before we even get to the adjudication that actually led to this judgment, there were 2 earlier attempts by Chartered to initiate adjudication that went nowhere.
Right.
The first one failed because they approached the wrong nominating body to appoint an adjudicator.
Okay.
They incorrectly used the RICS instead of the RIBA as specified in the contract.
Right. So nominating bodies like the RIBA have specific rules for how they appoint adjudicators, and using the wrong one can invalidate the appointment.
And then the second attempt actually fell apart because Charter didn't serve the referral notice within the required time frame.
So the referral notice is that crucial document that formally outlines the details of the dispute being referred.
Yeah, it really highlights how important it is to get the procedural steps right when you're initiating adjudication. Even these seemingly minor errors can completely invalidate the process.
It's amazing that they would make that kind of mistake twice.
Yeah. So 3rd time's the charm, though. On September 30th, 2009, Chartered served a 3rd notice of adjudication on Mrs. Liu. And this time they correctly applied to the RIBA for the nomination of an adjudicator. And the RIBA nominated a Mr. Slegg. And Miss Lee, understandably concerned about this, immediately emails Mr. Slegg. And she raised several objections about the validity of this 3rd notice. She pointed out that it didn't clearly state when the dispute had actually arisen, which she understood to be a mandatory requirement. She also pointed out that this notice listed the exact same 8 disputed items as that failed second adjudication attempt. And critically, she argued that none of these items were actually genuinely in dispute anymore, given those prior settlement discussions. And that the notice didn't actually explain how any actual dispute had arisen, given that. So she's basically saying, you know, hang on, this shouldn't even be happening.
Yeah, so she's trying to challenge the adjudicator's jurisdiction from the outset.
Yeah, she's saying there's no valid dispute here because of those prior conversations and all the errors that they've made.
It makes sense, given how flawed the first 2 attempts were.
Yeah, and despite these concerns and her challenge to the adjudicator's jurisdiction, Mrs. Lee did actually actively participate in the adjudication process. She specifically referenced the settlement agreement in her submissions. And she even presented her own detailed calculation of the sums that she believed were actually due. Suggesting that, in her view, Chartered actually owed her money.
Interesting.
Over £32,000, according to her calculations.
So she's participating. But she's all
challenging it.
That's a pretty common approach in adjudication, you know, to contest the process, but also defend yourself on the merits of the claim.
Exactly. So now we get to the really crucial part of this case, which is the timing surrounding the adjudicator's decision. So under the scheme for construction contracts, which governs these adjudications, the adjudicator initially has 28 days from the date of the referral notice to reach their decision. This time frame can be extended to 42 days if the party initiating the adjudication agrees, or even longer if both parties agree after the notice has been served. In this case, the initial 28-day period would ended around the end of October 2009. However, on November 3rd, 2009, Mr. Slegg emailed both Mrs. Lee and Chartered requesting an extension until Friday, November 13th. And both parties explicitly agreed to this extension for him to reach his decision. And this is where a really important distinction comes into play in adjudication. And that is the difference between reaching a decision by the deadline and issuing or delivering that decision to the parties. These are treated differently under the rules.
So the scheme also says that the adjudicator should deliver a copy of the decision to each party as soon as possible after reaching a decision.
So then on November 12th, which was the day before that agreed upon deadline to reach the decision, the adjudicator sends another email to both parties. And in this email, he states that he anticipated finalizing his decision by midday on the 13th. Which would have been within that time frame to reach it. However, he goes on to say that due to the necessary typing and proofreading, the decision likely wouldn't be ready to be emailed to the parties until Monday, November 16th. And he then asked if either party had any objection to this delay in issuing it. Mr. Reeves from Chartered responded later that day, saying, we have no objection. Monday will be fine. But crucially, Ms. Lee didn't reply.
Oh, so Chartered agrees.
Chartered agrees.
The delay in issuing.
Yeah.
But Ms. Lee doesn't
respond at all.
That's a big detail.
Huge detail. Then on the afternoon of Friday, November 13th, which was the deadline for making the decision, Mr. Slegg emailed both parties again, confirming that he had now reached his decision on the matters before him.
Yeah.
But he said it was being typed and he anticipated it would be issued on Monday, November 16th. The email containing the decision was finally sent late in the afternoon on Monday, November 16th.
Okay.
However, right above his signature, the decision was made 13th of November, 2009.
Interesting.
And in his decision, he found that Mrs. Lee owed Chartered a total of over £79,000.
Wow.
Which included the outstanding balance on that final account, VAT, interest, and his own costs and fees for conducting the adjudication.
Right. So he reached the decision on time.
On time, yeah.
But the actual communication was delayed.
It was delayed, yeah.
And as we'll see, that's a big deal.
Huge deal.
Legally.
So this 3-day delay in issuing the decision is ultimately what formed the successful basis of Ms. Lee's legal challenge in the High Court.
Right.
So the core of her successful challenge was the argument that the decision was issued outside of that agreed-upon time frame.
Right.
And the judge in the High Court really carefully examined previous case law.
Yeah.
He cited cases like Barnes and Elliott, Cubitt, Bloor, Mott McDonald.
Yeah.
And these cases established this really important legal distinction between reaching the decision within that time limit and delivering that decision.
Right. Delivering or issuing.
Issuing it promptly after. The legal principle here is that while the parties can agree to extend the time to reach a decision, any delay in issuing the decision beyond what is reasonably necessary can make it unenforceable.
Right.
Especially if there isn't clear agreement from both parties for that delay.
Exactly. And in this case, the judge put a lot of emphasis on the fact that while Mrs. Lee had agreed to the extension to reach the decision by November 13th, she didn't agree to any delay in issuing it.
Right. And he noted that the adjudicator himself had explicitly stated in his email on the 13th that he had reached his decision by midday on that day.
Right.
So the judge said, well, there's no clear explanation here for this 3-day delay between reaching the decision and actually sending it.
Yeah. Especially given that email is a pretty instantaneous form of communication.
Exactly. Right. And given the adjudicator's professional standing and that he's, working for this big firm, Cyril Sweet, like, why the delay?
Yeah, you would think they would have the resources to get it out quickly.
So the judge basically concluded that the obligation to deliver that decision as soon as possible hadn't been met.
Right.
And this 3-day delay in the age of email without a really good explanation was deemed unacceptable.
Wow.
So ultimately, because that decision wasn't delivered promptly after it was reached, the judge said it was unenforceable.
Yeah, what a huge takeaway for anyone involved in adjudication.
Yeah.
A seemingly minor delay of just 3 days.
Led to overturning a £79,000 judgment.
It's incredible.
Yeah, it really emphasizes how important those timelines are.
Absolutely.
Not just reaching the decision, but delivering it as well.
Both are equally important.
Yeah. Now, Mrs. Lee also raised several other challenges to the adjudicator's decision.
Okay.
And the judge actually considered some of these to be triable issues.
Okay.
Which means they weren't definitively decided in this summary judgment.
Yeah.
But they were significant enough that they could have potentially formed the basis for a full trial.
Right.
If this, issued out of time argument hadn't succeeded.
Yeah.
So one of those triable issues was the argument of invalid appointment of the adjudicator.
Okay.
Ms. Lee argued that Chartered might have actually requested the REBA to nominate Mr. Slegg before they had even served the notice of adjudication on her.
Right.
And according to the rules, that notice has to be served before you request a nomination.
It has to be done in the right order.
Yeah.
Yeah.
Yeah. And there were conflicting accounts of when exactly things happened.
Okay.
And the judge decided he couldn't really resolve that without a full trial.
Yeah. You need all the evidence.
Yeah. So that order is crucial.
Absolutely.
Serving that notice first and then requesting the nomination is absolutely crucial.
If you get it wrong.
Yeah.
It could potentially invalidate the whole thing.
The whole thing?
Yeah.
Yeah. So another triable issue identified by the judge was Mrs. Lee's argument that those emails from May 2009, where both parties talked about dropping their claims, actually constituted a legally binding settlement agreement.
Interesting.
And if a binding settlement was reached, then there wouldn't be a dispute to go to adjudication over.
Right. It would already be
done.
Yeah. And the judge felt that there was a genuine question about how to interpret those emails and the circumstances to figure out if they did legally form a binding settlement.
Right, because that would directly impact the adjudicator's jurisdiction to make a decision.
Yeah, so just the way they worded those emails.
And what was intended was unclear.
Right.
And that would have had to be decided at a full trial.
Yeah, if it had gotten that far.
Right. So finally, Mrs. Lee also raised the arguments of breach of natural justice by the adjudicator.
Okay.
And that the referral improperly included more than one dispute. But the judge dismissed these.
Okay.
He reasoned that an adjudicator doesn't get to decide the limits of their own jurisdiction.
Right.
And importantly, that Mrs. Lee had the chance to present her case.
Right.
On the more than one dispute argument, he said, really the main issue was the disputed final account. Right. And all the individual items didn't constitute separate disputes for the purpose of adjudication.
So the judge wasn't really sympathetic to those arguments?
No, not at all.
Okay.
So bringing this all back to you listening at home, what are the key takeaways from this?
Yeah.
Well, firstly, the importance of those timelines in adjudication. We can't stress this enough, right?
Right.
Both for reaching a decision and for delivering it.
It's both.
Yeah. So make sure you understand those timelines and that everybody agrees to any proposed delays.
Right.
In issuing that decision.
Especially the issuing part.
Yeah. Secondly, be incredibly careful when you're having those informal settlement discussions.
Right.
If you think you've reached an agreement, get it in writing.
Yes, absolutely.
Clear, unambiguous terms and make sure all the formalities are done.
Yeah, like exchanging those signed documents.
Yeah, in this case, that conditional exchange really was a big failure.
Yeah.
Third, really understand those procedural steps for initiating an adjudication.
Absolutely.
Right.
Yeah.
Any little error in that notice or in appointing the adjudicator can have huge consequences.
Absolutely.
It could invalidate the whole thing.
Yeah.
And finally, it is so valuable to understand all the terms and conditions in your contract.
Yeah.
Especially those clauses dealing with dispute resolution.
Absolutely. You've got to understand what you're getting into.
Yeah. And what's really striking to me is how this seemingly minor technicality, this 3-day delay in sending that email,
incredible,
led to a £79,000 judgment being overturned.
It's amazing.
It just goes to show that even the smallest details can have huge consequences.
Yeah, especially in formal processes.
Like this. So it really begs the question for you listening. How often in your own dealings, whether it's professional or personal, could a minor detail like this have a big impact?
Absolutely. It's definitely something to think about.
It is, yeah. Thanks for joining us.
Thanks for listening.